Let's jump into ethical considerations in New York. All right, our goals, let's talk a little bit about ethics, how they apply in our workers' comp cases. There hasn't been a lot of changes in the world of ethics that apply to us. In fact, very few ethical opinions have been issued in New York that have anything to do with workers' compensation. So for a lot of you, this is going to be a reminder of stuff you already know. I'm going to talk about two new things, actually three new things. I'm going to talk a little bit about record reviews. I'm going to talk about the new RPCs surrounding successorship of law firms. I'm going to sprinkle in a couple of the little adjustments that have changed or are changing now. I also want everybody to walk out of here knowing what the red flags are in your workers' comp case or things that could happen to you in court, that if they happen, you should come down to my office and tap me on the shoulder and say, Greg, this weird thing just happened in my hearing. Or if I'm not around, please find Declan or message us and say, hey, I see one of these red flags. Can you help? All right, so we'll talk about that. There are a lot of sources of ethical rules and things that apply to us as practitioners in New York. I should also say, for our paraprofessionals in the room who have chosen to sit mainly in the back, every rule of professional conduct that applies to attorneys is imputed to the paraprofessional that's working with them. So we can't ask you to do anything that we ethically are barred from doing. The big rule here is if it ever feels weird, like you're being asked to do something that you don't feel comfortable with, please come see me or any partner, right? What are the things that people get in trouble with that we never do here at LOIS? We never sign other people's names to documents. We never backdate documents. We never change post dates or issue certification saying we mailed something on a mailing date. We didn't do that, right? Those are some of the most basic things that we'll never, ever do. There's a lot of rules and guidelines that apply to us as practitioners. Some of them apply to every member of the bar. Those are in the rules of professional conduct. Those are contained in the rules of court. Then we've got some case law and decisions that apply to us. The New York State Bar Advisory Committee also issues opinions and decisions that, they're not precedential, but they are certainly guidance that we rely on. There's some stuff in the workers' compensation law that applies to us and provides boundaries on what we can do. And the board has even issued standards for civility before the board. Again, not authority, but just good guidelines for appearing before the board and being civil and polite. And I know sometimes that's tough to do. And the other guidelines that we have to talk about today are how we communicate with healthcare providers, because that's a huge source of potential problems for us. So I'm going to talk about this in two contexts. First, I'm going to talk about the ethical rules that apply mainly to claimants attorneys, and then many of them apply to us as well. And then I'm going to talk about the ones that we have to be specifically aware of, concerned about as defense counsel representing carriers. And we know there's a lot of context to this in the real world over the last 2 years. A lot of RICO claims and fraudulent behavior is coming to light, and we're seeing all these articles that are published about how is it possible for dozens of claimants to all live in the same apartment or apartment building, because we know there's a lot of fraud in our system. We know that, right? Anytime you design a system that delivers money to people, and that system is designed with, quote, liberality and generosity towards the claimant, close quote. That's what it says in the statute. That's what this case law says, that this is supposed to be mainly a one-sided system that's here to deliver money and benefits to people, right? That's what our system's designed to do, and does it very well, by the way. Well, anytime you make the rules really favorable to one side, that really does invite in a lot of waste, fraud, and abuse, and we see that in our cases. So these ethics issues, they are absolutely present in our matters, and we see them. And my computer is frozen. Oh, here we go. Attorney fraud and asking others to do things which contribute to a fraud, that's an ethics violation, right? All the law firms that have been named as defendants in these RICO suits, they don't just have a RICO suit problem. They also have a problem with the State Bar Association, and they have a problem with potential disbarment. So in addition to all the civil penalties and criminal penalties they face, they also could be stripped of their professional licenses, right? These are things that happen in the real world. Let's talk first with stuff that happens primarily with claimants counsel, the inception of the relationship with their client. And by the way, this is probably one of the most common things I'm having to talk about with the grievance committee and explain to the grievance committee. When the claimant's attorney begins representing the claimant, that representation formally begins with the filing of that OC 400, right? They can't get a fee in a workers' compensation case unless they've filed that form. That's the creation of the relationship. Now, they may have an agreement or a fee arrangement or anything else. They're allowed to have that on the side, but their formal representation before the Workers' Compensation Court begins with the OC 400. This is one of the chief problems that I have when I speak with the grievance committee. Because what does claimant's attorneys say when they violate the rules of ethics and start directly communicating with our clients? They say, well, Greg, you didn't file an OC 400 in the case, so you're not actually representing a party in this case. Like, you don't count. I don't have to include you with communications. That's not true, and I'll talk about that in a few more slides. But that's how their representation begins, and it's required in every case. For them to withdraw or sub out, the court has to approve it. Why? Because the court doesn't want to get a whole bunch of pro se claimants who don't understand the workers' compensation system appearing in front of them. But we've seen the issues that arise when claimants' counsel are maybe collecting clients through suspect sources. When the Subin firm withdrew from 300 cases all at once, their associate went into court and said the reason we're withdrawing his counsel is because we have suspicions about the referral source of all of these claimants. Okay. Again, attorney fraud on its basis in that we see in so many comp cases, that's an ethics violation. Client contact is one of the biggest challenges for claimants counsel. Not for us, right? Because we're LOIS Law Firm. Like, we respond to emails and we call people back. Just nod your heads, make me feel better. Okay, good. Yeah, we do that. Okay, that's an important part. But we're also required to do that. And all clients are owed a duty of communication about what's happening in their cases. I'm very suspicious about how much communication is actually going on with the other side. The lawyer must provide information to the client so the client can make a decision. But has this ever happened to you? It's happened to me. I make an offer in a workers' comp case, and maybe it's not a high offer, you know, it's $10,000 Section 32 offer. And adversary counsel will literally say to me, Greg, that offer's an insult. It's so low, I'm not even going to tell it to my client. I'm going to reject it right now. And I say, well, that's cute. But before you reject it, you have an ethical duty to go tell your client about that offer. Okay, that's something you can do. I've had cases where I was really suspicious that the claimant had no idea that we were making offers to settle the case. It's okay in direct examination of the claimant to say, hey, we're here today. I'm going to ask you some questions about the accident, you know, the mechanism of injury. I'm going to ask you some questions about your current impairment. But to start, do you recognize that we've made a settlement offer of $50,000 Section 32 to close this case? That's a fine question to ask. And if the claimant goes, what? I didn't know that. That's immediate argument. I think that the attorney's not doing what they're supposed to be doing. Okay, you can ask that question in direct. All right, so they have a duty of client contact, as do we. Now, contact with physicians and doctors. Okay, let's start first with treating physicians. Workers' compensation law, Section 13 says it's an undue influence to attempt to persuade a physician to engage in or stop engaging in any specific course of care. Okay, it's not unethical to ask them, hey, or against the rules to say, hey, what is the course of care? To get the records, you can communicate with them, but it's when you start to persuade them or ask them to change the course of care, that's where that becomes a problem. If we have to make an inquiry of a treating physician, we always do it in writing and we copy the other side. That avoids those ethical problems. Same thing with contact with physician experts. Everything that we're going to communicate with our experts has to be in writing, has to be copied to the other side, has to be copied to the board. I think we have a pretty robust process in place for that. I don't think that's something that gets challenged very frequently. And the same thing with the report coming back from the IME doctor. And New York has extremely stringent rules about how we can communicate with our IMEs. Now, you may know, I also practice in New Jersey. New Jersey has no such rules. In New Jersey, when I send the petitioner, because we don't have claimants in New Jersey, we only have petitioners, to an IME doctor, and the IME doctor sends me the report, I can then call up my IME doctor and go, hey, I read your report, I don't like it. Here's what you didn't address, or here's what I'd like you to address, or here's what you left out. Could you change this wording? Can you change these words down here? Can you change the percentage of disability? And the doctor and I can communicate that about that, no problem. And they'll be, oh, sure, I'll write you another report, Greg. And they rewrite the report and send it over to me because I'm allowed to collaborate with my expert in New Jersey and work with them and make sure the report looks good. Okay. Now, you guys all have these looks of horror on your face, like you what? Because we know you can't do that in New York, okay? Because the experts, even though they're not really impartial, right? Because we're paying them, they really are expected to be more independent than what we would consider a defense medical exam or an independent medical exam in New Jersey, okay? So just totally different set of rules and a pretty stringent set of rules. Every time I flip through this, goes through 5. All right. Now, that same set of rules does not apply when we do a physician record review. Okay, so we know if we're getting an independent medical examination, which is going to include a physical examination of the claimant by the independent medical doctor, we know that we've got to follow all the rules under Section 13 and Section 137, which says no verbal contact. Everything that we say to the doctor should be in writing, and it's going to be copied to all the parties. All the medicals are going to be copied to all the parties. We know all of those things. But that does not hold true when we do a physician record review. So if we ask the physician, hey, we don't want a physical exam. I just want you to take a look at all these medicals, and I want you to give me your determination based on what you're seeing, just to presume everything in the medicals are true. Does this person need the surgery? How disabled are they? Is this course of care truly curative? Have they reached maximum medical improvement? You can ask all of those questions. The doctor sends you the report. You have no duty to turn that report over to the other side. None, 0, unless you're going to use it in court. If you are going to use it in court, then you have to turn it over to the other side 3 days before the court proceeding. All right, why am I stressing this? Because I don't think we use it enough. I think it's a pretty effective way that we can get maybe a second opinion on ongoing treatment, maybe a surgical request, maybe something where you're looking at the surgical request and you're like, well, it's going to be a $20,000 surgery. Maybe it's not worth going through all the litigation around getting an IME, et cetera. You say maybe a record review. Okay, that's one opportunity. And with the intention, by the way, of using it in court. You could also get a records review for the intention of not putting it into court. I just want to get it so you get a sense of what's going on in this case and if this treatment is truly curative and necessary, or if the claimant really has reached maximum medical improvement, or if there really are objective signs of worsening, or whatever it is that's the issue in your case. It's a lot more cost effective to do that. And so there's a whole court rule, section 300.2. That's a section of the regulations that deals with independent medical exams and record reviews. This is the rules are very different, a lot more favorable to us. And then it goes on to say that none of these rules apply if the reviewing physician is an employee of the carrier. So this is where I'm going to stress to you, knowing your client is important. We have a very large client that we serve in this company that are headquartered in Omaha. And they have an on-staff medical doctor who will do record reviews at any time of any case for us internally. And no ethics rules apply to that, and certainly none of the court rules about record reviews apply to that. In fact, the court rule specifically says it does not apply to the carrier's own medical staff. So doing an internal medical records review, particularly in a case where you're challenging the necessity of maybe care that we think is wasteful or not going to be curative, that might be a cost-efficient way of doing things. And again, it sidesteps all these problems of the risk of getting an IME. We've all gotten IMEs that have destroyed our case because the IME doctor rendered an opinion that was entirely unfavorable, or it was partial, or sometimes it's just paternalistic. Sometimes they just gave credence to the claimants, all their complaints and their litany of pain descriptions. All right, so be thoughtful about the use of record reviews, the judicious use of them, both from a budgeting perspective, like they're less costly, they're quicker, they're something you can keep in your back pocket if they're not favorable to you. Like maybe that helps you guide your client. Like, hey, we did get a records review. The records review says, yeah, they do need the surgery. Okay, that maybe helps us avoid unnecessary litigation. Okay, so just think about the records reviews. I don't know if we do them enough. I think that's something that we could adjust our practice with. All right. The other thing is we have to do this stuff because the system is full of crooked actors, and there's a lot of crooked doctors out there. I think this case came out last year, and we started talking about it a lot. I know when we were doing deposition training that Christian was leading last month, we talked about the fact that doctors are using transcription services that are using AI to complete the narratives. There's all sorts of issues that we're going to see with that. I think that are going to come forward. But look, there's actual schemes out there where they're paying claimants $1,000, $1,500. In the tradesman suits, they're saying $5,000 bonuses to get surgeries, right? And so that's obviously an example of the kind of thing that our job to root out, okay? We also have to be thoughtful that it might not just be undue influence between the claimant's attorney and the doctor, the treating doctor in the case. Dr. Ribeiro wasn't doing this for the benefit of the attorneys. He was being directed by the litigation funding company, right? A litigation funding company was actually the party that was kind of directing and sort of controlling this fraudulent course of unnecessary surgeries. So think about the fact that you got to ask these questions in the doctor cross-examination. You know, did you communicate? We always ask the question, did you communicate with anybody before this deposition? Anybody in the claims attorney's office? Anybody at a litigation funding company? We should ask anybody, right? Those are the questions we should ask, because the crooked doctor might not be talking to the plaintiff lawyers. They might be just talking with the litigation funding company, who's then funneling cases to the crooked lawyers, right? So we have to be mindful of all of these possibilities. The penalties for undue influence are really not that stringent, which is, I think, why this goes on a lot more on the other side. The penalty is, oh, whoopsie-doo, that doctor's notes are kind of precluded out of your case. They can't bring in the notes, they can't rely on them, and they can't cross-examine the physician. It's like it never happened. Okay. I've had cases, and we've talked about the Paksinski decision, where opposing counsel was clearly directing the treating physician in how to testify. When this came out on cross-examination, I asked the question, we should always, did you talk to anybody to prepare for today's deposition? Treating physician says, yes, I talked to the claimant's counsel. And I said, well, I'm raising, this is absolutely inappropriate. It's undue influence. No way. I've been prejudiced. My client's prejudiced. Go before the judge. You know what adversary said? Well, Your Honor, I don't just represent this claimant Paksinski in the workers' comp context. He also has a civil action. That's the action over the workers' comp case. And I represent him in that context. And by the way, in New York Supreme Court, under the civil rules, they are allowed to communicate with treating physicians. So it's a pretty clever sidestep, I think, to say, hey, these undue influence communications, these persuasive discussions I had with him, prepping him for his deposition, that was in the context of the civil action, okay? The judge didn't buy it. The board panel didn't buy it. They threw out the doctor. All right, conflicts of interest. We rarely see this in the kind of context that we see it, where it's like, I actually have a conflict with this client because I'm representing a party adverse to them in another case, right? So we have that. This comes up for us. Intake takes care of us. When there's a workplace accident, usually involving an OSIP or construction accident, multiple parties that are alleged to be the employer will try to retain LOIS Law Firm to defend them all at the same time. And then, John has the fun job of, picking the winner of the beauty pageant as to who we're going to represent, right? Usually it's the first person who asks us. Less likely that you see those kind of conflicts on the claimant side. But I can tell you, you will see those conflicts of interest for the claimant whenever the attorney's been involved in a fraud. Because now that attorney is a witness, maybe against their own client, in one of the tradesman dispute or RICO cases. You can't, in one context, be accused of spurring on fraudulent behavior and a witness in a case and also representing the claimant in another context at the same time. It's very difficult. I don't see how they can sort of thread that ethics needle, which is why I suspect the Subin firm was dropping all those clients so fast, because they recognize this is going to become a conflict for them. So be mindful of that, that potential. Last thing we'll talk about, the second to last thing we'll talk about for claimants attorneys and us is the duty of candor towards the tribunal, which is we have to tell the truth. Boo, boo. We have to. You can't hide things. We're never going to create false evidence, any of those types of things. We have to tell the truth. What's the number one context this is being violated now? It's in the news all the time. Candor towards the tribunal, or the duty of fair dealing towards the judge. Using AI to write briefs that cite cases that don't exist, right? You're misleading the court, you're misleading the opposing party. We've all seen those things that are coming out. Last thing I'll talk about for the claimant's attorney's perspective, again, it also applies to us. You're not allowed to communicate directly with a represented party. It's like the basis of our entire justice system that you're not supposed to do this, right? You're not allowed to do that. That's the point of having attorneys, to stand between the client and the tribunal, to stand between the client and their adversary. That's our whole job. That's the description of attorney. That's what the word means in Latin. This comes up in our cases, unfortunately, more and more frequently. I started talking about it right at the beginning. Claimant counsel directly communicating with a represented party, meaning our client most typically. I think it happens by accident a lot. In an email chain, maybe by accident, maybe not on accident, but sometimes by accident, they copy in our client, the risk professional, the adjuster, the claims professional. We've seen this happen, okay? Our policy here at LOIS is when that happens, we point it out to them immediately. Please do it in the email chain itself. Just hit reply and say, oh, whoopsie-doo. I think you did a little bit of a whoops here. You copied in my client. You know you shouldn't do that. Don't do it again. That kills most of it, most of the time. But sometimes they persist in this behavior. And there's been some claimants attorneys who have put themselves, gone through mental gymnastics to explain why they believe they can do this. Okay, they'll say the most ridiculous things you can possibly hear. They'll say things like this in writing to me. Greg, I've been doing this for 20 years. I always just communicate with the claims professional. What? Did you just admit to a 20-year-long pattern of ethics violations? Because I think you did. Or they say, well, in other cases, when they're represented by other attorneys, not LOIS attorneys, they don't care that I copy them in on settlement discussions. Okay. There's a lot of bad defense counsel out there that shouldn't be allowing you to do that. Or they'll say, oh, well, you know, I get a better deal, or I can settle cases faster if I just directly communicate with your client, cut you out of it. And I'm like, whoa, that's not a good reason either. So our policy here is, well, when they do that stuff and you see that happen in your case, the first time, please write them a very polite civil email like, hello, silly heart, I think you just did something by accident here. Please don't do it again, okay? When they do it the second time, that's willful, okay? It's willful. Forward it to me, okay? That's my role, okay? So my job as managing partner in this company, I also act as general counsel. Like I negotiate our contracts and our leases, and I also am the person who pursues grievance complaints against attorneys who act unethically, and I'm the person who brings these ethics issues before the ethics committees. Why me and not you? You're closer to it. Why me and not you? Because I don't want you to be a witness in any of those cases, and I don't want to conflict you out of defending the underlying workers' compensation case, right? That's your job. My job is to protect you from that. So if that happens to you, flip it forward to me. Now, do I have grievance complaints pending? Yes. Unfortunately, we have to do that. I also have written to the Office of Attorney Ethics and asked them to write me an opinion, a precedential opinion that just says, hey, in a workers' compensation context, can claimants counsel directly contact a represented party? Like very simple, straightforward. I'm still waiting. It's been 4 or 5 months now. I'm waiting for a response from the Office of Attorney Ethics. I want a published opinion from them so that we can just wave it around, right? And I've heard all sorts of crazy arguments from opposing counsel. They'll say to you things like, well, I don't see your OC 400. That means you don't represent the party. Therefore, you're not a party and I don't have to communicate with you. That is nonsense. In every single case, I believe, I'm looking at our intake master over there, we send a notice of representation to the board and we send it to plaintiff's attorney and we send it to the plaintiff. Okay, so it's there at every single case and that's what we rely on, all right? So that's ethics issues in a nutshell for claimants counsel, the big ones that I see. Now let's turn over to ours because we have a separate set of ethics issues and relationships that we have to navigate. The first one is, unlike in almost any other area of law, In almost every single case that you defend, you're going to have at least two clients. Okay? The one client is going to be the actual employer. The other client is going to be the carrier. We owe the same duty of fiduciary responsibility and ethical obligation to both of those clients. But if those clients are ever in conflict, we actually owe the highest duty to the employer first, right? That is our duty. That's who we serve. The ethics opinions on this are there's a lot of them, because it wasn't until really the 1940s when you have industrial scale work, insurance and insurance carrier defense becoming its own like subspecialty in the bar, that they have to start addressing this. But the ethics opinions and the first case on this is the Employers Insurance Company versus Goebel. Now, I'm going to read this. Remember, this is written back in the 40s, and that's why they always refer to the attorney as he. We have female attorneys now. Quote, when counsel, although paid by the casualty company, meaning insurance company, undertakes to represent the policyholder and files his notice of appearance, he owes to his client, the assured, meaning the insured, an undeviating and single allegiance. His fealty embraces the requirement to produce in court all witnesses, fact and expert, who are available and necessary for the proper protection of the rights of his client. It is immaterial that such procedure increases the cost to the carrier beyond the policy coverage limit. In other words, the carrier's duty that they owe a defense to their client exceeds even their policy limits. That's why when we're defending a case, and I want us to defend every single case like it's going to go to trial, like it's going to be on the front page of the Wall Street Journal, okay, that level of attention, our second consideration is how much does this cost to defend? I want us to be reasonable, but that's not our most important issue. How much does this cost the insurance carrier? Most important issue is what facts and evidence do I need to marshal? What witnesses do I need to bring in? What investigation do I need to conduct so I can present a full and zealous defense of my client without regard to what the cost of that is going to be? Because my duty, your duty, our duty is always to the employer. Case law says the insured is our client and therefore deserves our total fidelity, despite the fact the insurance company pays our fees. That's an important statement to make, but also from a business perspective, that means that some of our clients, like the big insurance carriers who spend millions of dollars a year here, they're actually in the second position. The person in the first position is their policyholder. That could be this little mom and pop that's only going to ever have one workers' compensation claim in their whole history, and we're going to defend it. That's who we owe the duty to. And it's a tough thing when you think about it. Hey, you'd think we should owe more allegiance to the insurance carrier, which over the course of the next 10 years might spend $50 million here at Lois Law Firm. But that's not correct. Our duty is to the employer, and it's undeviated. Most workers' compensation contracts say the workers' compensation carrier can settle workers' comp actions without the consent of their insureds. So most of the time, we're not asking our employer, hey, are you agreeing with this, nuisance value section 32 I'm doing? Okay, it's not. Now, tempering that is the fact that we have a lot of clients who are not self-insureds, so it's all their money. It's simple to deal with them. We have a lot of clients who are high deductible clients or high retention clients. And so what those people do is they go out and they sign a contract of insurance with big giant insurance company. But that contract says the first $500,000 of any loss, workers' comp loss, that's on me, the employer. And it's only after the first $500,000 that you, the insurance company, pays, right? That would be a high deductible policy. Well, there might be a self-insured retention part of the policy where the first $1 million of every loss, whether it's for defense cost or for indemnity or medical, comes out of the self-insured or the high deductible insured. Regardless, we do know that, right? Know what your client's retention is, whether it's a self-insured retention and how much, because it might be their money. So you don't even need the carrier's input into whether you're going to settle the case. You're certainly going to loop them in, but you're going to go and resolve that case directly. When the client is purely insured, the insurance company has a fiduciary obligation to put the benefit to the insured ahead of their own benefit. So in other words, If your insurance carrier client ever says to you, yeah, we're not doing so well in our stock market investments right now, so we're not paying out settlements this month, that's wrong. I mean, that's a violation. That's a conversation you should come have with me, because that's not a valid reason for them to not be paying out in a workers' compensation case. Okay. Now, we don't have any of these potential issues or concerns with a self-insured employer. You should know who your clients are that are self-insureds. Believe me, they'll tell you why, because it's their money from dollar one. So they care a lot. You know, the kinds of clients who are going to elect to be self-insured are either saying, I can't efficiently get workers' compensation coverage in the general market because it's just going to cost too much. It'll put me out of business. Or B, I'm very sophisticated and I understand my business far better than any insurance carrier is ever going to. And therefore, I think because I'm sophisticated and smart, I can administer my own risk and actually do better without having this big insurance company standing behind me. Either way, either of those two decisions, they're going to be very cost conscious and try to be as efficient as possible in their cases. You know, sometimes I say they're my most demanding clients, right? Because this is their money. This money comes out of their bottom line. So when we tell them, hey, we've got to go settle this case for $500,000, well, we just took $500,000 of operating profit out of that company. They might not be able to buy pencils or paper clips next year because of that. So they feel the pain. It's a lot different than when you have an insurance company standing in the middle. Because there's no tripartite role and there's no workers' compensation insurance policy, right? Because they're self-insured, that means we can engage in things like doing general releases, doing resignations, giving other types of advice or guidance, because there is no workers' compensation policy, which is governing the relationship between them and the insurance carrier, right? That we have a lot more latitude to provide them different types of advice. All right, clients issue legal billing guidelines. Why? Nobody likes paying for lawyers. I don't like paying for lawyers. You don't like paying for lawyers, and nobody does. So clients issue these legal billing guidelines and they send them to me. And sometimes I take a big red marker and I scratch out, hey, this won't work, that won't work. That's a part of what I do with prospective clients, is make sure that their legal billing guidelines are not so restrictive that we can't effectively provide a defense. Some of the things I've seen in these legal billing guidelines, I think, violate the duty and fidelity that I owe to the insured. And so we tell them we can't do this kind of work for you. Some of the things I've seen are things like imposition of an arbitrary budget. Like you can't spend more than 10 grand. We only allocate $10,000. Some clients ask us to do flat fee. I'm like, well, that's impossible for us to do. Limitations on how many hours a day an attorney can work on a specific case for them. And then I've had clients who've come forward and said, we actually want to impose a limitation on how many hours a day your attorney can work on all of your clients' cases, meaning not just mine. And they want to be able to audit that and to figure that out. Challenging our ability to present a complete and thorough defense. Saying, hey, we don't do investigation, or discovery has to be concluded in 30 days, or we're not going to do disclosure in this case. Any of those types of things in a litigation billing guideline can violate our ethical duty as attorneys, and we can't accept work from those types of clients. So just be on the lookout. We don't have that problem here, but it is a potential problem for defense attorneys. The other potential problem we have is when there is a workers' compensation insurance policy, which is a contract, right? When clients, and it could be the employer and it could be the carrier, ask us to do things that exceed the contract. You cannot go to the market and buy a workers' compensation insurance policy that covers resignations of employees. Why? It violates public policy. It's in the workers' compensation statute, right? You can't do that. So when the insurance carrier comes forward to you and says, oh, we're only going to do this section 32 if you get us a resignation, that's not really a valid request, because it exceeds what they have the authority and responsibility to do under their insurance contract. Our policy here is that when an insured client, whether it's the employer or the carrier, asks us to do a resignation or a release or any other thing that exceeds the workers' compensation insurance policy contract, our policy is we send an email over to New File. We open up a completely separate matter directly with the employer, and then we can engage with them directly. And what we're going to ask for them is essentially to do a scope of representation. Hi, employer. I represent you now only for the purpose of getting this resignation or getting this general release across the finish line. And hello, employer, you waive any conflict of interest that could occur because I'm now also representing you in another context in the workers' compensation case, right? So that's our policy here. And I think it's best practice. It's safest for them, and it doesn't get the insurance carrier in trouble. Now, could we do it? Yes. But I think the insurance carrier is now engaging in behavior that could result in increased modification factor, increased insurance costs for that employer in the future if it's billed under the workers' compensation policy. And that's the practical reason why we don't do it as well. Not just for an ethical reason, but also for a practical reason. All right. I swear I click it and it takes a second. All right. We owe the same candor towards the tribunal that the claimant's attorney does. And I want to stress that that's even when the case is unopposed and we have a pro se and we know we could probably say just about anything. We have a duty to tell the truth. I think that duty goes a lot further though. And that's why I always stress, like, we don't change dates on things. We don't backdate things. If anybody ever asks you to do that here, please come see me. That's inappropriate. We don't do that. Okay. Sworn pleadings. Every time an attorney signs anything, and anytime one of our paraprofessionals does, just be thoughtful. That's a sworn pleading. That's the same as an affidavit. You're certifying that. You're putting your license at risk. Don't sign anything that you have not fully read, right? Okay. All right. We also have a duty to cooperate with opposing counsel and communicate with them. So just like we have a duty to communicate with our own clients under RPC 1.1 and 1.2, we also have a duty to communicate with opposing counsel. Do they always communicate so nicely with us? No. But our goal is to keep them involved in litigation, get them working with us. We want to be as cooperative as we can. There's no rule against civility. You can be a strong advocate and still be polite and courteous. Like, we don't have to cross any of those lines. The rules say we also are not allowed to engage in frivolous litigation. And if anybody has worked here for long, you know, that is one of the things that the judges love to threaten us with. They say, well, you know, if you pursue these defenses, Mr. Lois, you've got a denied case. You filed your pre-hearing conference statement. If you pursue this, this could be frivolous. This could be a frivolous controversy. Okay? I do not want anyone to be scared of a frivolous controversy penalty. I don't think we pursue frivolous controversies here at all. Do we get hit with those fines? Yes. Do we appeal all of them? Yes. Don't worry about that. I haven't seen us do things that are frivolous. I believe that is primarily an empty threat intended generally to get us to abandon our strong positions of advocacy and to not be as persuasive as we could be. All right. Conflicts. We do have a lot of conflicts at this point. We're litigating over 4,000 cases right now. Our backlog of how many cases is probably in the 10,000 plus range. So this does emerge. Conflicts are something that we check at intake. We confirm that we don't have any conflicts at the time of the case. But I'm going to stress this little point that it just happened to us in one of our cases. As your case develops and as new parties are added to your case, refer it back to New File for a conflict check. Okay, we just had a case that we came in and we started defending the case and we had to present a witness. And the witness was a co-employee. And the co-employee was going to come into court and corroborate that the accident never took place. Okay, so the employer gives us a witness name. We communicate with the witness. The witness is like, yeah, I'm ready to come in and testify. Great. Problem. We need to run a conflict right at that moment because it turns out that witness, that co-employee witness, was also a claimant in a prior workers' compensation case that we defended. Very useful information for you to know, right? So if you're defending a case and new parties are coming in or the employer's giving you witnesses that you're going to present in court, Okay, you're going to produce them, run a conflict check. And that's a best practice. We should be doing that, right? So if that comes across your desk, please do that. In general, though, we resolve most conflicts pretty easily. We just refuse the representation. All right. Some other issues. There's some red flags that I want you to be on the alert for. I warned you in the beginning that I was going to give you a couple thoughts to apply in your cases. So here's some red flags, right? You're litigating your case. You're defending your case. It gets heated, right? In the racing world, we call that seeing the red mist. Your vision just gets down to a tunnel and you're angry and you're making your points and you're doing the best you can. And things are said, threats are made, and the judge says to you, because the judge is actively participating in the case, well, I might find a 114-day penalty against the employer here. Red flag. Okay, that's a moment to take a step back and start to reevaluate. When during the pendency of your defense, the other party says, actually, your client acted in a discriminatory fashion towards my client, and there was a undue employment incident because of this. They got fired. They got written up. They didn't get a promotion. They got put on the bad shift that nobody wants to work. They got to work all Saturday, whatever it is. Well, that's a potential discrimination case. Okay, that's a red flag. When the judge says that you, the attorney, are going to be a witness in this case, that's a huge red flag, a huge ethical problem. Okay, I had an attorney tell me that she used to like to Google up all the claimants and see what they were up to and go on the social medias. No, we don't do that. Okay, do not Google the claimants. Do not find things out about them on social medias and then put those in documents or try to confront them with it. Why? You just became a witness in your own case because the proof that you're intending to confront them with, that you're going to proffer as parole evidence of the claimant's credibility or their impairment or their functional ability, whatever it is, whatever reason you thought that was a good idea, you're the person who generated those proofs. You're going to be the person who had to authenticate those proofs, and you are now a fact witness in your own case. Do not do that. Our practice here is if you think, oh, this person's, they're younger and they're active on social media, or we think we get these hints, or the adjuster tells us, hey, co-employees are saying they're very active on social media, that's a great opportunity for an investigator to go perform that investigation, not us, right? Because now you're going to become a witness. Another red flag is where the judge says, well, there might be a 114A violation here. The employer threatened the employee or did something wrong or hid evidence or turned in a fake payroll or turned in a fake first report of injury, whatever they're accusing the employer of doing. And the judge says, I'm going to ask the employer to appear here at the next proceeding. And you might want to tell them to get their own attorney because a 114A violation carries a criminal penalty against the employer. Now, it's a misdemeanor. No one's going to jail over it, but it is a criminal penalty. When they say those words to you, you should come back to the office and tap my shoulder or come see Declan because something has gone drastically wrong and we have to make sure we're not getting into an ethical problem. Again, sometimes it's just bluster. I think 99% of the time it's just bluster or threats or positional statements. But if you see one of these things, a conflict issue, and again, be thoughtful about after acquired witnesses and names that are coming into your case as potential fact witnesses that we need a fresh conflict check. Employers being accused of fraud, there's a discrimination aspect, or anyone else who should never be appearing in court, like an adjuster or you or your staff, your paraprofessional has been named as a witness. Huge red flag. Come see us. All right, takeaways as we conclude this ethics tour. There are many sources of ethics rules in New York. They fill in the gaps. They govern our behavior. They apply to everyone, all parties. I would also stress that they apply to our paraprofessionals. They apply to our front reception desk. They apply to our office services people. They apply to everyone that works here. It is always, we're doing something that's unethical and we ask someone else in the office to do it, it's imputed to us. I believe that our value of professionalism, I believe we demonstrate a high degree of professionalism, particularly in light of the environment that we litigate in, which is not exactly awash in professionalism. I think we are a great example of doing things the right way and trying to do things the right way. Trust your gut. If it feels weird, wrong, like this doesn't seem like something we should be doing, please come see me. I don't even want to get close to the edge of any of these issues. It's not worth it. It's not worth your license. It's not worth your career. It's not worth your not sleeping at night because of a potential ethics violation. Please come see me. And if you see any of those red flags, come bring them to me as well. I love pursuing, protecting everyone from unethical behavior. That's part of my job, so I don't mind doing it. So if someone, again, is communicating around your back with your client, pursuing unethical things, presenting false testimony, come bring it to me. I will help you sort those issues out. That's all I got for today. Thank you, everybody. Have a great day.